Ready? Start. It was contended in appeal that the appellant number 2, the owner of the offending vehicle, had deposited the necessary fees along with application for issue of route permit, and the same was issued on 27th February 2013. It was further urged that when the owner of the vehicle had already submitted the documents in the transport office for grant of permit along with the requisite fees, the tribunal was in error in holding that the vehicle was being plied without a valid permit. In support of the submission, reliance was placed upon the High Court scrutinized Annexure A1, which was filed to justify the stand that the application for issue of the route permit was made to the competent authority, and on a scrutiny of the same came to hold that the owner had not been able to establish that he had submitted the application for issue of permit before the accident. Referring to section 66 of the act and placing reliance on C. Bharat case, the High Court opined that even assuming that the owner had already applied for grant of the permit before the accident, the same would not entitle the owner to play the vehicle. It is worthy to note that the learned single judge distinguished the decision cited before him and resultantly confirmed the award of the tribunal. We have heard Mr. Sudhir Walia, learned counsel for the appellants, and Mr. Amit Kumar Singh, learned counsel for the respondent insurer. Para. The conclusions recorded by the tribunal and further confirmed by the High Court clearly showed that the accident occurred on 19th February 2013 and the competent authority issued the permit. In this regard, sections of the Act that define motor vehicle or vehicle and permit are motor vehicle or vehicle means any mechanically propelled vehicle adapted for use upon roads, whether the power of propulsion is transmitted thereto from an external or internal source, and includes a chassis to which a body has not been attached and a trailer, but does not include a vehicle running upon fixed rails, or a vehicle of a special type adapted for use only in a factory or in any other enclosed premises, or a vehicle having less than 4 wheels fitted with engine capacity of not exceeding 25 cubic centimeters, and permit means a permit issued by a state or regional transport authority or an authority prescribed in this behalf under this act, authorizing the use of a motor vehicle as a transport vehicle. On a perusal of both the definitions, it is quite clear that a permit has to be issued by the competent authority. Full stop.